Good afternoon. I'm Chilton Varner, President of the Supreme Court Historical Society. It is my pleasure and honor to welcome our virtual members who are joining us for today's lecture, given by one of the Society's very best friends. As the pandemic continues and the Supreme Court building remains closed, the Society is working hard to make accessible to its members the kinds of communications they have grown used to and enjoy. As we explore this new landscape, your feedback is vital. You'll get a survey later today, and we urge you to take the brief time it will take to respond. We are eager to have your feedback on whether we are on the right track and are there other things that you would be interested in the Society undertaking. We take your feedback very seriously. The Supreme Court Historical Society has not been sitting still during the pandemic, despite the closing of the court building. Our staff has been busily at work, working remotely. As many of you know, the Society's longtime executive director, David Pride, retired on February 1. If you are interested in some of the tributes that have been given to David's considerable impact, check out our website at supremecourthistory.org, where tributes have been posted. I'm also delighted to share that the stewardship of the Society has passed virtually singularly into the very capable hands of Jim Duff. Jim is a familiar name and face to the Society, having served as an aide to Chief Justice Warren Burger, as administrative assistant to Chief Justice William Rehnquist, and 2 separate stints as director of the Administrative Office of the Federal Courts. I hope you will join me in welcoming Jim on board. He will be participating in our program this afternoon, so you can start right now. Today's program features a lecture from Professor Brad Snyder on, quote, baseball, Curt and the Supreme Court. He will talk for about 30 minutes, and then he will take questions from the members of our virtual audience. Please submit your questions in the Q&A function of your Zoom connection. Jim Duff will be selecting questions to share with Brad. Brad teaches constitutional law, constitutional history, and sports law at Georgetown University Law Center. He's also the author of a book entitled The House of Truth, a Washington Political Salon, and the Foundations of American Liberalism. Prior to teaching in an earlier stint at the University of Wisconsin Law School, Brad worked as an associate at the well-known private practice firm, Williams Connolly, headquartered in DC. He's also written 2 critically acclaimed books about baseball, including the one entitled, quote, A Well-Paid Slave, Curt Flood's Fight for Free Agency in Professional Sports, end quote. We can see where he got the inspiration for today's lecture. A graduate of Duke University and Yale Law School, Brad clerked for the Honorable Dorothy Nelson on the U.S. Court of Appeals for the Ninth Circuit. Brad has been the most loyal of friends to the Society. He has spoken several times to the Society before, lectures that all met with high regard and interest. He has always been willing to share with the Society his information, his wisdom, and his guidance. So we'll now turn the program over to Brad Snyder. Take it away, good friend.
Hi, Chilton. It's great to see you, and I look forward to being able to see you in person and welcome Jim. and thanks to David for his past service as executive director of the society. I also wanted to thank Jennifer Lowe, the program director, for arranging this event, my family, some of my old law school friends, and a few semi-coerced students who are watching today. So thank you very much. I'm going to spend only a little time on Curt Flood, the baseball player, and focus more on his Supreme Court case, just because I think that's what will be of most interest for the society's members. But for those of you like me who weren't even born when Curt Flood was playing baseball, and if you could go to my second slide here, Curt Flood was really a star player, not a superstar player, but a star player. And he was a 3-time All-Star, a 7-time Gold Glove winner, and he had participated in 3 World Series. The photo on the right was actually a cover of Sports Illustrated beneath the caption, "Baseball's best center fielder." That's Curt Flood catching a ball in the ivy at Wrigley Field. And that cover really alienated Willie Mays fans everywhere who thought Willie Mays was the best defensive center fielder. But Flood by 68 had become just that. Next slide, please. On October 7th, 1969, Flood, who was the longest serving member of the St. Louis Cardinals, was traded to the Philadelphia Phillies along with Tim McCarver for Dick Allen. And Flood's reaction to the trade was he wasn't going. And the reason why he refused to go is because in those days, there was no free agency in professional sports. Players were bound up in something called the reserve system, where they signed contracts each year, which said, we own you for this year, and we own you for next year too. So players like Flood, who had been on the Cardinals for 11 or 12 years, had really no say in where he was able to play. And in 1969, the Philadelphia Phillies was not an attractive place to play. They were one of the worst teams in the league. They had given Dick Allen and other Black players a terrible time. Flood's former teammate, Bill White, had been traded to Philadelphia and told him how bad it was playing there. Flood described Philadelphia as the northernmost southern city. So Flood said, I'm not going to Philadelphia, even though the Phillies offered him more than $100,000 to play for them. And that's superstar, more than $100,000 in 1969 was star or superstar money. That was sort of the threshold for a superstar contract, because salaries under the reserve system were really held down below market value. So Flood consulted with a lawyer after he said he wasn't going to Philadelphia, a St. Louis attorney and a good friend of mine named Alan Zerman. And Alan Zerman suggested that Flood talk to the executive director of the Major League Baseball Players Association, Marvin Miller. And during that conversation in New York City, Marvin Miller, who wasn't a lawyer, but a former economist for the Steelworkers Union, said, this is a 1,000,000 to 1 shot, this a potential lawsuit against Major League Baseball over the reserve system. And if this million, and even if this 1,000,000 to 1 shot comes home, you'll never see a dime of it, because those contracts were legal in the past. They might not be legal in the future, but they were legal in the past. Plus, Miller understood that Major League Baseball was insulated from the antitrust laws, which I will discuss in a moment. But Flood asked Miller in return, will my lawsuit benefit future players? And Miller told me, he said, he told Flood it would benefit future players, and Flood replied instantly, that's good enough for me. So Flood and Miller together agreed to sue Major League Baseball. Major League Baseball Players Association agreed to pay for Flood's legal fees in exchange for being able to pick Flood's counsel. But let me talk a little bit about the antitrust exemption. If you could go to my next slide. So baseball was exempt from the antitrust laws, and most people think that baseball is exempt from the antitrust laws because of a 1922 decision by Oliver Wendell Holmes known as federal baseball. But as Kevin McDonald's really great Journal of Supreme Court History article shows, all Holmes said in his federal baseball opinion is that Major League Baseball, as conceived in 1922, did not rise to the level of interstate commerce as defined at the time. And as we know by decisions about goods crossing interstate lines made by child labor in Hammer versus Dagenhart, the definition of interstate commerce in 1922 was quite narrow. It did not exclude things as manufacturing. The following year, the vaudeville industry tried to get an exemption, quote unquote, because it tried to analogize itself to baseball, and Holmes said no. He said that the transportation of vaudeville performers made it different than baseball and may make it fall under the definition of interstate commerce. Where baseball was really exempt was in a 1953 case involving a minor leaguer named George Earl Toulson. And the Supreme Court, which was led at that point by Chief Justice Warren, who had not even been confirmed as chief, he was sitting as a recess appointment, claimed in a per curiam opinion, he said, basically what Holmes had instructed people to do was, look, we need to look again in 1953 to see if Major League Baseball as an industry is interstate commerce, and based on that 1953 definition of interstate commerce, which was much broader after the New Deal constitutional crisis. But instead of doing that, the court issued a per curiam opinion, refusing to re-examine the underlying issue of whether or not baseball was exempt from interstate commerce, and claiming that Congress, in passing the Sherman Antitrust Act in 1890, had intended to exempt baseball from interstate commerce. Well, there is nothing in the text of the Sherman Antitrust Act that says that, and there is nothing in the legislative history that says that, because Congress had no intention with regard to baseball. But that's what Toulson said, and that basically exempted a suit against the reserve system as an antitrust violation, as price fixing, as a group boycott. That's why Marvin Miller thought it was a 1,000,000 to 1 shot, but Curt Flood was not deterred, and he wanted to go ahead and sue. Could I go to my next slide, please? The person that Marvin Miller hired to litigate Flood's case was Arthur Goldberg, former Supreme Court Justice Arthur Goldberg. Goldberg and Miller had worked together at the Steelworkers Union when Miller was an economist and Goldberg was the union's general counsel. Miller remembered during the steel seizure case how great an oral argument Goldberg had made before the Supreme Court of the United States, and saw Goldberg both as a former justice and former Supreme Court advocate as the ideal person to take on the case. When Goldberg, who was at that point, he had been Secretary of Labor for President Kennedy, then Kennedy had appointed him to the Supreme Court of the United States to replace Felix Frankfurter. And then Goldberg had resigned from the court only a few years later to become ambassador to the United Nations because of Lyndon Johnson's promise that if he became ambassador to the United Nations, that Goldberg would be able to end the Vietnam War. Well, obviously that proved not to be true. And Goldberg regretted the decision of leaving the court. And at that point that he was hired by Marvin Miller, he was a partner at the law firm of Paul Weiss. In discussing the case, Miller had read in the newspapers that Goldberg was thinking about running for governor of New York. And Miller asked whether Goldberg was running. And Goldberg said no, and he promised Miller that he would not run for governor of New York and stay involved in the case. Well, Goldberg went back on that promise, and it sort of presaged sort of things to come in which Goldberg's heart and his full attention maybe wasn't involved in the case. The case, could I have my next slide, please? The case really began with what is really considered to be the Emancipation Proclamation for professional athletes, which was a letter from Flood to the Commissioner Bowie Kuhn on December 24th, 1969. And that letter says, "Dear Mr. Kuhn, after 12 years in the major leagues, I do not feel that I am a piece of property to be bought and sold irrespective of my wishes. I believe that any system which produces that result violates my basic rights as a citizen and is inconsistent with the laws of the United States and of the several states. It is my desire to play baseball in 1970, and I am capable of playing. I have received a contract offer from the Philadelphia club, but I believe I have the right to consider offers from other clubs before making any decisions. I therefore request that you make known to all the major league clubs my feelings in this matter and advise them of my availability for the 1970 season. Sincerely yours, Curt Flood. A few weeks after that, in early January 1970, after Bowie Kuhn, the commissioner of baseball, replied denying Flood's request to be a free agent, Arthur Goldberg filed suit in the Southern District of New York, alleging that the reserve system was in violation of the antitrust laws, that it was in violation of federal antitrust laws, it was in violation of state antitrust laws, and it was in violation of the 13th Amendment. And we'll get to some of those arguments in a minute, I promise. Can we see the next slide? For some reason, the trial judge in the case, Irving Ben Cooper, rather than dismiss the case for lack of federal jurisdiction because baseball was exempt from the federal antitrust laws, decided to hold a trial. And 3 people who were associated with Major League Baseball testified on Flood's behalf. And one of those 3 people was Flood's lifelong hero, Jackie Robinson. Yesterday was Jackie Robinson Day in Major League Baseball. I'd be remiss in pointing that out. I'd also be remiss in pointing out that early in his career, Curt Flood wore number 42 in honor of Jackie Robinson, and after a few years changed his number to 21, which was half of Jackie Robinson's number. Neither of those were coincidences. This lawsuit for Flood turned out to be an absolutely miserable experience because he was sitting out the 1970 Major League Baseball season. But the moment Jackie Robinson, who had cataracts, his vision was poor, he was battling heart disease and diabetes and another of other health problems. But the moment that Jackie Robinson walked into that courtroom and whispered in Flood's ear to keep his head up, that he was doing the right thing, that meant everything to Curt Flood and really inspired him to see his lawsuit to the end, because Miller and Goldberg both told him that the only way Flood would win this case was if Toulson was reversed by the Supreme Court of the United States. So the Jackie Robinson testimony was a real highlight. The other 2 figures in Major League Baseball who testified on Flood's behalf were former Detroit Tiger great and executive Hank Greenberg and then former Chicago White Sox owner Bill Veeck, or maybe he was former Cleveland Indians owner, soon to be Chicago White Sox owner Bill Veeck. Flood's lawsuit, eventually Irving Ben Cooper dismisses the case for lack of jurisdiction because of Toulson. The Second Circuit affirms, and the Supreme Court grants certiorari. So that 1,000,000-to-1 shot is totally possible by this point. And that really brings us to oral argument and to the preparations of the briefs and oral arguments. Arguing on Flood's behalf was Arthur Goldberg, which was probably and definitely in hindsight a mistake. Goldberg hadn't argued before the Supreme Court in many, many years. He had another talented Supreme Court advocate actively working on the case and really leading the case on a day-to-day basis, the late great Jay Topkis. But Goldberg insisted on arguing the case, and not only did he insist on arguing the case, he refused to do any moots or preparation for the oral argument. On the flip side, the lawyer representing Major League Baseball during the bulk of the argument was a 36-year-old Wilkie Farr and Gallagher partner, and another one of my good friends named Lou Hoynes. And Hoynes, who was arguing the case in conjunction with an Arnold and Porter partner, Paul Porter, who was representing Commissioner Kuhn, elected to do a large moot court. And the head of that moot court, that sort of mock oral argument at Arnold and Porter was none other than former Associate Justice Abe Fortas. Fortas had not been back to his old firm. His old firm elected not to take him back when he resigned from the Supreme Court. But as a favor to Paul Porter, Fortas came back to the offices of Arnold and Porter, and Hoynes and Porter engaged in an elaborate moot court, and Hoynes gave a terrific oral argument before the Supreme Court of the United States. Unfortunately, if you could go to my next slide, Arthur Goldberg did not do a great job at oral argument. He may have been sort of too far removed from his last Supreme Court argument. He may not have prepared sufficiently. He also may have just had some sort of shock or fright in being in arguing in front of his former colleagues. He was very close with several justices on the court, most notably Justice Brennan. And on March 20th, 1972, Goldberg seemed to just get caught up in the facts. He started in the facts and launched into a factual recitation of the case, and then sort of started over again. And each time the justice might ask a question about the legal aspect of the case, Goldberg would say, "I'll get to that in a minute," which of course is a cardinal sin of oral argument. Hoynes, on the other hand, was really masterful during his portion of the argument. And Hoynes's argument was, this is a labor issue. This isn't an antitrust issue, and we should resolve it at the bargaining table and not in the court. If you could go to my next slide, I'll sort of summarize the three arguments for each side on the table because they're tricky. So if Goldberg had laid out his legal arguments, he would have laid them out as follows. His main argument was baseball should overrule Toulson, and because baseball in 1972 is clearly interstate commerce, given the elaborate minor league system and television and what have you. That was his easiest way to win. His harder argument, and one he'd been pressing all the way along, was if Toulson is still good law, and if baseball is only intrastate commerce and not interstate commerce, then state antitrust law, such as New York's antitrust law, must apply. That was really a tricky argument for the court, and one we'll see. The last argument, and the one he did not press in his Supreme Court briefs and merely noted in his Seventh Circuit appeal, was an argument based on the 13th Amendment. And in 1968, just 2 years before Flood filed his lawsuit, the court decided a case called Jones v. Alfred Mayer, which applied a federal civil rights statute, section 1982, to racially restrictive housing covenants, because the right to own property was a, quote, badge and incident of slavery, right? And that that Congress had power under its enforcement provision in section 2 of the 13th Amendment to eradicate those badges and incidents of slavery. Well, if Goldberg had pressed that 13th Amendment argument in conjunction with state antitrust laws, that would have given him federal jurisdiction, even if the federal antitrust laws didn't apply. Those are all tricky arguments, but the 13th Amendment argument was never made in the briefs, and Goldberg really never made an argument before the justices on the day of his argument. Hoynes's arguments were a little more straightforward, but the second one's tricky too. Hoynes obviously says, look, we have this thing called stare decisis. We follow precedent, and you should follow Toulson and follow federal baseball because Congress hasn't changed the statute, the Sherman Antitrust Act. This is really in Congress's hands and not the courts. That's his easiest way to win. But really the main argument Hoynes was making before the court was that this is a labor issue, not an antitrust issue, and he had some support because there was a growing doctrine starting in 1967 in a case known as Jewel T, that if something has been collectively bargained, then it is exempt from the antitrust law. That opinion was made by none other than Arthur Goldberg himself when he was an associate justice in a concurring opinion in Jewel T. That argument was also advanced by Ralph Winter in a Yale Law Journal article that said professional sports leagues should not be able to sue, or maybe professional athletes should not be able to sue under the antitrust laws if they have collectively bargained their rights away. And that article was pretty influential to Hoynes, pretty influential to some of the justices, and it was a tricky one for them to handle. As Hoynes sort of said to me when I was researching the book, he was really walking a tightrope by pressing this labor exemption argument. It's referred to today as the non-statutory labor exemption, because if he won on those grounds, Major League Baseball would have lost its exemption as it related to the minor leagues and to franchise relocation. It would only extend to things that were collectively bargained. The court eventually, in 1996, in a case written by, in an opinion written by Justice Breyer, eventually reached this result in a case called Brown v. Pro Football Inc., involving a practice squad player for the NFL. So that's the oral argument. 5 hours after the oral argument, the justices go into conference and they vote. And next slide, please. And the justices go into conference and they vote, and the score, if you will, is 5-4 for Major League Baseball at conference. You have Justice Stewart as the senior justice in the majority, along with Justices White, Thurgood Marshall, William Rehnquist, and Harry Blackmun, who was sort of the justice, Blackmun being the justice most on the fence. The justices who had voted for Curt Flood at conference were Chief Justice Burger, William O. Douglas, William Brennan, and Lewis Powell. But a bunch of really unusual things, that's an unusual lineup, and a bunch of unusual things happened after conference. If you could go to my next slide, please. So the unusual thing that happened at conference, first of all, Potter Stewart is a senior justice in the majority, assigns the case to Harry Blackmun because Blackmun's most on the fence. But here's where weird stuff starts to happen. Lewis Powell recuses himself from the case because he owns stock in Anheuser-Busch. And during his confirmation hearings, Powell, who was a rainmaking partner at Hunt and Williams in Richmond, had told the United States Senate that he would recuse himself in any case in which he owned stock. So that made it 5-3 for Major League Baseball. At that point, Harry Blackmun holds himself up in his secret library at the Supreme Court with his baseball books and begins to write. After Blackmun, I'm sorry, it says Black, but I mean Blackmun. After Blackmun circulates his draft, Thurgood Marshall switches his vote to Curt Flood, deadlocking the case at 4-4, which means there would be no Supreme Court opinion, and the Second Circuit's opinion would be allowed to stand. But at the last moment, Warren Burger switches his vote from Curt Flood to Harry Blackmun, giving him a 5-3 majority. And as Jim Duff knows, and as many other people know, Burger and Blackmun had a long history. They had grown up together in the Minneapolis-St. Paul area. Blackmun was the best man at Burger's wedding, and they were great friends until they joined the court together. But at this moment, Blackmun's only 2 years in to his time on the court, and he and Burger are still relatively close. They have not yet become the frenemies that they became in later years, and that it is documented in the Brethren, which I'll get to on my next slide. So Blackmun holds himself up in the secret library writing this opinion, and this is really the famous part of the case. And he holds himself up with these baseball books, such as Lawrence Ritter's Great Oral History, The Glory of Their Times, and other baseball history books, and writes this introduction that is unlike any other Supreme Court opinion because it is an ode to baseball. It has references to Casey at the bat, and most controversially, it has a list of 88 baseball greats, which Blackmun obsessed over. Now, the first draft in Blackmun's papers, and I should say as an aside, when I was researching and writing this book, Blackmun's papers opened up in 2003. And I had never used the justices' papers before. I thought all the justices' papers were like Harry Blackmun's. Well, they aren't. Harry Blackmun was a pack rat. He kept everything. He kept slips of paper from the Supreme Court bench when Potter Stewart would pass him notes about the scores of baseball playoff games that were going on while the court was in session. He also saved all of his notes and drafts that we know of Flood v. Kuhn. And that first draft did not omit the names of the three Black players included, Jackie Robinson, Satchel Paige, or Roy Campanella, contrary to the story in the Brethren that Blackmun had initially omitted those Black players. What is also true is that Stewart, when he agreed to join Blackmun's draft, he asked for one change. And Potter Stewart, of course, is from the city of Cincinnati. He's from a longtime Cincinnati family. He asked Blackmun to include in his list of baseball greats Cincinnati Reds pitcher Eparixi. Blackmun agrees. Well, the law clerks began getting in on the fun here, and you know how law clerks are. They can be sarcastic and somewhat mocking. One law clerk called Blackmun's chambers and suggested that Blackmun add ex-Senators pitcher Camilo Pascual to his list of baseball greats. Well, Blackmun took this mocking suggestion really seriously. And for those sort of baseball dorks among us, Pascual had a lifetime record of 174 and 170, a 3.63 ERA, which isn't bad. But he also have, for you really modern baseball fans who are into sabermetrics, a 40.9 WAR, wins above replacement, which would put him among some of the bottom rung Hall of Famers. But Camilo Pascual is no Hall of Famer. Blackmun excluded him from his list. Blackmun's list, which he worked on until the very end of the case, it contained one notable omission, and that's the Hall of Fame catcher Mel Ott. And when that was brought to his attention that he admitted Mel Ott from his list, Blackmun was mortified. And much later on, during his time as a justice, perhaps 7 or 8 years later, his law clerks presented him with a Louisville Slugger bat, Mel Ott bat, to commemorate that event. If you believe, and I agree with the great legislation scholar Bill Eskridge, you can understand the entire Supreme Court opinion of Flood v. Kuhn based on Blackmun's ode to baseball. But not all of the justices were thrilled with that ode to baseball in the list of baseball names. Even though Berger had switched sides and gave Blackmun a 5-3 majority, both he and Byron White refused to join that fact section, part 1 ode to baseball. So to be super technical about it, that ode to baseball only received a plurality of justices and is not Supreme Court precedent in any way, shape, or form. Can you go to my next slide, please? The problem with Blackmun's opinion is, and really with his draft, is how little time he spent on the reasoning. And I know I'm a little bit over my time, but I want to get to this because I think it's important. Blackmun ruled that Major League Baseball was interstate commerce and that the state antitrust law claims were preempted by federal antitrust law. But he claimed that Congress, by its positive inaction, had affirmed Toulson's exemption. And any students of statutory interpretation know that the positive inaction of Congress is kind of an oxymoron, because Congress's default position or its baseline is inaction. And in fact, since Toulson, Congress had failed to pass laws expressly exempting Major League Baseball and other professional sports. So Congress's inaction really doesn't point in one direction or the other. And Blackmun's reliance on positive inaction is really a weak read. Next slide, please, for me. Oh, I don't need it. If you could go back to my first slide, that would be great at this point. I want to talk about Douglas and Marshall's dissents, because Douglas's dissent was quite good, and he was dissenting from the beginning, and he had been really strong on trying to provide players' rights under the antitrust laws. When he was sitting as the circuit justice for the Ninth Circuit, he held that the NBA draft violated the antitrust laws in a case involving Spencer Haywood. Douglas's dissent described Toulson's exemption of Major League Baseball when none of the other major sports were exempt from the antitrust laws as derelict in the stream of the law, and really ridiculed Blackmun's congressional inaction, that positive inaction argument. Thurgood Marshall's dissent, remember he had switched his vote, was a little more measured. He would reverse. His dissent argued that they should have reversed and overruled federal baseball in Toulson, but remanded to the trial court on the labor exemption issue. Ralph Winter, who had written that 1971 Yale Law Journal article, was Thurgood Marshall's first law clerk on the Second Circuit Court of Appeals. And I'm just guessing, but I'm guessing that Thurgood Marshall read that law review article and found it persuasive. In any event, on June 19th, 1972, the Supreme Court announced its decision in favor of Commissioner Bowie-Kuhn and against Curt Flood. Flood, who had made an aborted comeback with the Washington Senators in 1971, had by this time fled to Mallorca, Spain. Arthur Goldberg never argued another Supreme Court case again. But really today, Curt Flood's case is really, most people have a false notion of it, that somehow Curt Flood was baseball's first free agent. He is not. He lost his case, but he helped future players in the following way. Flood's lawsuit forced the owners to sort of put their money where their mouth was, and that this was a labor issue and not an antitrust issue. And in the 1970 collective bargaining agreement with the Players Association, the owners made two critical concessions. They agreed to grievance arbitration before an independent arbitrator, not the commissioner. And they agreed to something called the 10 and 5 rule, which means that if you have 10 years of major league service time and 5 with the same team, that you can veto a trade, which would have, in retrospect, have allowed Flood to veto his trade to the Philadelphia Phillies. That grievance arbitration system allowed Catfish Hunter to press his breach of contract claim against Charlie Finley and become baseball's first free agent, and allowed Messersmith and McNally to test the language of the so-called reserve clause, in which an independent arbitrator held that it was a one-year option and not a perpetual option, and really paved the way for free agency. The court today, or since Flood v. Kuhn, rarely, if ever, cites Flood v. Kuhn for any proposition other than excessive devotion to statutory stare decisis. The Curt Flood Act of 1998 removed baseball's antitrust exemption for MLB labor issues, but the exemption still stands on everything else. But to me, LeBron James and other sports megastars of today owe all of their power and control over their careers to Curt Flood. Thank you very much. Jim, you take it away. Jim, you're muted.
Unmute, here we go. Thank you very much, Brad. Fascinating account, and very topical as we see issues percolating today. And I'll remind you at the end of our questions, Brad's book is available at our Supreme Court gift shop, signed copies of it, and I encourage you to purchase it. It's a great read. Between now and when we wrap up, we will be taking questions. And if you would please type them into the Q&A section, and we'll get to as many of those as possible. As I think we're getting some now. One of the first questions that I've seen is, does Curt Flood belong in the Baseball Hall of Fame? And Brad, you're an expert.
Yeah, this is a tricky question. The Baseball Hall of Fame is a private organization. It's technically not affiliated with Major League Baseball. On his numbers as a baseball player, I don't think Curt Flood belongs in the Hall of Fame. If you just look at his numbers, he has a little more than 2,000 hits. He has a 293 lifetime average. As I said, he was a star player, but not a superstar player. But if you add in his contributions to the game of baseball, there is an argument that he belongs in. And I think, given that I'm a lawyer, I like to look at precedent. I think the closest precedent for Curt Flood's inclusion in the Baseball Hall of Fame would be Larry Doby. Larry Doby started his career in the Negro Leagues with the New York Eagles. He was the first Black player in the American League, playing for the Cleveland Indians. He only played about a dozen years in the major leagues, maybe less, and doesn't have Hall of Fame numbers. But given his contributions to the game as baseball's, as the American League's first Black player, Doby, I think rightly belongs in the Hall of Fame, and Flood may belong in under similar criteria, especially now that the Hall of Fame much too belatedly admitted Marvin Miller, the executive director of the Major League Baseball Players Association, into the Hall of Fame.
Interesting. You had mentioned earlier that Chief Justice Berger and Justice Harry Blackmun went to school together. They went to grade school together in St. Paul, Minnesota. I find it was fascinating, and in your book, and I knew this because I grew up in the Cincinnati area, was a Cincinnati Reds fan, but Curt Flood's high school, you mentioned that you came from Oakland, California. His high school outfield was Frank Robinson, Veda Pinson, and Curt Flood at McClellan's High School in Oakland. All three played Major League Baseball. And the Hall of Fame question reminded me that Frank Robinson's in the Baseball Hall of Fame. And I thought Veda Pinson ought to have made the Baseball Hall of Fame too.
So I agree with you, Jim. Like in my last question, Veda Pinson has much better numbers for the Hall of Fame than Curt Flood. He's pretty close to 3,000 hits.
Yes.
Flood actually transferred out of McClymonds to a different school, but what they had all in common was that they had the same American Legion coach, a man by the name of George Poles. Okay. And Poles became a feeder or a scout for the Cincinnati Reds. Now, all three of those players initially signed with the Cincinnati Reds. And of course, the Reds, in kind of a disastrous move, traded Flood from the Reds to the Cardinals. And this is the sad aspect of it. Pinson and Robinson thought because an all-Black outfield in the late 1950s wasn't going to be palatable in Cincinnati or almost any other major league city, particularly a border city like Cincinnati. So Flood was shipped out to St. Louis early in his career, and I think that exacerbated Curt's feelings, right? Because he had worked hard in the Reds organization, and then to be traded to the Cardinals after a few years in the Reds organization, he never wanted to be traded again.
Interesting. Yeah, I didn't realize that. I thought, well, I knew they were at the same high school at one time.
Yes.
And I thought they played in the same outfield in high school at one time, but pretty amazing. And that was the same high school Bill Russell went to.
Correct.
In the Basketball Hall of Fame. So
it's an amazing group of athletes, right, to come out of that high school. And San Francisco, it's not totally accidental because there was a lot of work in the shipyards in Oakland and San Francisco, and a lot of African-American families migrated from Texas, from the South to the Bay Area, and specifically to Oakland. It was really a melting pot of people there, really interracial teams. Flood had grown up playing on interracial teams, which was why his experiences with segregation in the Southern minor leagues really fired up his sense of injustice.
Thank you, Brad. The next question we have, in view of the 5-10 rule, Flood in practicality won the case. How did he feel about the impact of the case?
Well, I think it depends when you asked him. He was very bitter and very sad in 1972. He had a really hard time after his baseball career ended. As I said, he had exiled himself to Spain. He had battled problems with alcoholism. And it really wasn't until sort of 1986 when he married his former girlfriend and a former Hollywood actress named Judy Pace that he got his life together. But in 1994, when I was when I was a reporter for the Baltimore Sun, Curt Flood, this was the height of the baseball strike. Flood was speaking to the major league players in Atlanta and got a standing ovation, telling the players to stay strong and to fight for their economic rights. So he really embraced his role and his contributions to baseball and professional sports free agency. So he felt good about it, and that 10-5 rule reverberates today for the Oriole fans who are in attendance. Adam Jones was with the Orioles for quite some time, and late in his career with the Orioles, he rejected a trade by invoking the 10-5 rule. So this still gets invoked by veteran players all the time, and has a lot of power.
That feeds into the next question we have from the audience, which is, how did Flood's fellow players weigh in about the suit at the time? Were they reticent to express views, or did they speak up? Was there a dissent? I'll add to the question: was there a dissenting movement among players?
Yeah,
and maybe I'll add another little bit to the question. Was the Players Association as unified and powerful then as it may be today?
No, I mean, the short answer to the last part of your question is no, right? Marvin Miller had just taken over as executive director in 1967, the beginning of the 67 season, and he was still sort of building and educating and sort of trying to make progress at the bargaining table. This was not the ideal timing for this lawsuit for Miller. But the player representatives met in Puerto Rico at their annual meeting, and those player representatives put some hard questions to Curt. Tom Haller, the San Francisco Giants, Roberto Clemente was there, Reggie Jackson was there with the Oakland A's. They put some hard questions to him, but they voted unanimously to fund and to back Curt's lawsuit. What happened was, later on, was rank and file players were less united. What was shocking to me, Jim, was how many superstar players couldn't see that that this lawsuit would really benefit them. So you had superstar players like Harmon Killebrew of the Minnesota Twins and Carly Yastrzemski of the Boston Red Sox, who were very well taken care of by their owners, who spoke out against Curt's lawsuit. There were other players like Frank Robinson, like Willie Mays, like Hank Aaron, who stayed completely silent about Curt's lawsuit for fear of being traded, right? I think what's hard to remember during this time, Willie Mays got traded during this time to the New York Mets. Frank Robinson got traded twice. Hank Aaron ended his career with the Milwaukee Brewers, right? So there was sort of a climate of fear, even among superstar players, many of whom refused to speak out, and a few who spoke out against Curt's lawsuit.
Did another question from the audience: did Flood ever speak about the lawsuit after the result?
Sure. Where Flood's most eloquent about it is in Ken Burns' baseball documentary, and it was really an essential interview, and really kind of brought Flood to the baseball public's attention. That Ken Burns documentary culminated when it was launched with a Rose Garden meeting with President Clinton and his wife, and so Flood and his family were invited and met the Clintons and met the other players. And I think it was the first time, apart from the 1994 Atlanta meeting with the player representatives, that Flood was really brought back into the game of Major League Baseball. He was really an outsider looking in for so long, and that Ken Burns documentary really brought him back in the fold, and that White House visit really brought him back into the fold.
Interesting. And Another question from the group, should Justice Blackmun have included Mellott in his list?
Well, I mean, the short answer is, if we're in an oral argument, yes, he should have. Mellott is one of the game's greatest players. The better question is whether whether Blackmun should have been obsessing about that list or thinking more about his reasoning, and whether or not positive inaction is a good basis for a majority opinion of the Supreme Court of the United States.
A good, fair point. And I had a question too, and you may have addressed it sort of in the 510 or the 10.5 aspect of it, but given the strength, the added strength, I guess, of the Players Association today, and the collective bargaining agreement, if it's truly arm's length, that is, there are sort of each party has strength enough to make it an arm's length agreement, and it's not foisted on the players by the owners. Does that strengthen the owner's argument, if it's an arm's length collective bargaining agreement, that it fits into an antitrust exemption, or is that theory also weakened over time?
No, it's strengthened over time, Jim. You're actually absolutely correct. Because of Justice Breyer's majority opinion in Brown v. Pro Football Inc., any collective bargaining agreement in professional sports, anything contained in that agreement, is exempt from the antitrust laws. And Major League Baseball, the NFL, the NBA, the NHL, Major League Soccer, these are the only industries in America that want unions and want a collective bargaining agreement, because they know as joint ventures, the best way to insulate themselves from antitrust lawsuits is to put them in collective bargaining agreements. So Brown v. Pro Football Inc. was a real win for professional sports leagues, and really enables those professional sports leagues to operate as monopolies because of the non-statutory labor exemption, because all of the things are included, the status quo is included in the collective bargaining agreement. Very
interesting. And Brad, you're so knowledgeable about it. This has been wonderfully enlightening. I've enjoyed it. I'm sure our audience has too. And I want to thank you very much on behalf of the Society. Your book is on sale in the gift shop and online at www.supremecourtgifts.org. I'll hold it up to show the cover. A Well-Paid Slave, Curt Flood's Fight for Free Agency in Professional Sports by Brad Snyder. Brad, we're absolutely delighted you were with us today as we kicking off a baseball season that we hope we can attend games at this year. And well done.
Thank you. It was fun, Jim. I look forward to seeing you in person.
I do too. We're just right down the street from each other, so maybe we can take in a game together.
That would be great. That would be great.
Thank you, Brad.
Take care.